listening to the Esq.Marketing podcast, hosted by Matthew Lauren, president of Esq.Marketing, where he features successful solo and SMB law firms from all over the United States. Now, let's get started with the show.
Hello, everyone. I'm Matthew Lauren, president of Esq.Marketing, and you're listening to the Esq.Marketing podcast, where I share successful stories to help. Let me start that over. Hello, everyone. I'm Matthew Lauren, president of Esq.Marketing, and you're listening to the Esq.Marketing podcast, where we share successful stories to help build your practice. Today, we're joined by Toni Long. Toni is the managing partner and founder of the Long Law Group, which specializes in corporate and entertainment transactional work. Since founding the firm, Toni has collaborated with other attorneys and counsel clients on complex M&A and financing transactions totaling more than $400 million. Toni, welcome to the show. I know that was sort of a super quick intro, and I know there's a lot more to what you do, and I was hoping maybe that you could share a little bit more with us, straight from you, as opposed to me reading it.
Yeah, no worries. So that's what you said is absolutely correct. The managing partner and founder of the Long Law Group. My specialty is corporate and entertainment transactional work, but our firm has grown over the years, and we also have a labor and employment practice as well as a civil litigation practice. Basically, we see ourselves as kind of a one-stop shop for business owners and addressing any issues that come up through the life cycle of a business. So that includes, especially here in California, if you own a business, you're always going to have labor and employment issues. So we try and advise our clients on those. And sometimes litigation is one of those things that happens. You can't really control it. So we're there to represent our clients, make sure their interests are protected there as well.
That sounds really interesting. I know when our director of marketing, James, first told me that you were in entertainment law, is it? I was like, ooh,
yeah, entertainment practice.
That sounds really interesting. Like, I just picture you working with like entertainers and...
That's what people always think. I think people think entertainment is a lot sexier than it actually is in practice. There's very little of that. So that's probably a very small percentage of anyone's entertainment practice, generally speaking. And then there's a whole bunch of contracts, labor and employment issues, and other areas of the law that get implicated in entertainment. Because there's really no entertainment law per se. It's just an umbrella term that encompasses all manner of other practice areas that come together and impacts this one industry.
Understood. Now I don't have to feel like such a moron when I talk to people about it. All right, so let's jump right in here. Today's topic is about partnership agreements, why you need them, and what should absolutely be included in any partnership agreement. And for myself, working with attorneys, I guess this is just always something I thought attorneys just knew about no matter what their practice area was. But what is a partnership agreement?
Basically, a partnership agreement is just a legal agreement between owners of a law firm or any business, really, that will explicitly detail their relationship. It sets forth what I call the rules of engagement for running the business, for bringing on new partners, for dividing profits and losses, for handling disagreements. Believe it or not, sometimes lawyers disagree, for disposing of an interest in that partnership if a partner dies, is disabled, gets a divorce, or retires. And so those are really the major things that any partnership agreement should address. And that's it in a nutshell. So we're done. Goodbye. I'm kidding.
So why would business owners get a partnership agreement? Like, what are some of the main reasons to do that?
Well, ideally, you want an agreement that is tailor-made to your partnership, that's tailor-made to the way you're going to run your business. Not every business is run the same way. Not everybody has the same, experience, responsibilities, and what have you. And so you want something in writing that memorializes the agreement that you and your partners have agreed to as to how the law firm is going to be run. So if you don't have something in writing, the state has a plan for you. they have default rules. And oftentimes you think about default rules. Default rules are generally in place kind of as a catch-all and written in very general terms because they can't identify every particular scenario. So they tend to be very basic and not really tailored to what is happening in the real world. So you want to have something in writing in the event that you want to deviate from those default rules. And almost in every instance, people do want to deviate once they realize what the default rules are. So that's one reason to have a partnership agreement. You want to have some control over who owns your company. You want to agree on certain issues in advance before they become disputes. You know, who's going to make what decisions? Who's going to run this committee or that committee in the partnership or in the law firm? That sort of thing. What happens if you have a disruptive partner or a non-performing partner? How do you remove them from the company? You want to address that. And you don't want it to be a process that's so long and drawn out that it could kill your law firm. It could, tank your business. So those are some of the key reasons I would say you would have that. And also law firms are long-term investments for people. In this day and age, it's certainly not that expensive to start a law firm like it was, 30 or 40 years ago. And we've certainly learned in the past year that you can run many businesses from home rather seamlessly or at least with very few bumps. And law firms are the same in that regard. But you will want something that protects your investment in that business. Again, going back to certain actions that could imperil the business, that's money that gets lost if that were to happen, if that business were to tank because you didn't plan in advance. So the partnership agreement is your advanced planning on and taking care of issues in the event that things don't go as planned. And life generally does not go as planned.
That's for sure. The first thing you said caught my attention, and I didn't know there was default rules that dictate what happens if there's a disagreement. What are some of those?
You know what? I don't know if I know the default rules off the top of my head, but they are certainly codified in our statutes that govern professional corporations. So if you don't have rules for, bringing in someone or getting rid of a partner, you may be stuck with whatever the default rules are, and they may not move as quickly or as efficiently as you want. I'll be honest, I don't know all of the default rules, mainly because with my clients, we tend to vary those rules almost in every instance because people want something that's tailor-made for them. But yeah.
Do those vary by state, or is there?
Yes,
Okay.
they will vary by state. So if you're in California, we have one set of rules. If you're in Illinois, there's another set, Texas, another set. And that's not to say that they are all different in every state. Some states, will follow certain kind of model rules and institute those. But there will be variances per state. So I know there are certain things in California that may very much be very California specific. So if I were to be practicing in Texas, I'd have to bone up on the Texas rules to ensure that, number one, if I draft a partnership agreement, it's conforming to those rules, and also what I'm doing in practice conforms to those rules.
Obviously, without naming any names of clients or anything like that, do you have any horror stories of someone who didn't have something in place and had to follow the default rules and it wasn't ideal?
Yeah. And not in necessarily a law firm context, but we certainly have this with some of our corporate clients. I mean, we've had clients who had no agreement at all and needed to get rid of a partner, and that became a costly and time-consuming nightmare. We've had situations where clients have had an agreement, but it wasn't tailored for them. It was, essentially something they pulled from the Google School of Law or from the Google law firm, and it did not work out for them because it really did not take into consideration how they run their business. And that particular instance, one of the biggest issues was this person had a fairly sizable interest in the company, but they hadn't made their capital contribution. And so they were enjoying kind of the fruits of everyone else's labor and their work, and they weren't doing any work, and they hadn't made their capital contribution. But one could argue that their interest had vested. Now, obviously, if this had gone to litigation, we could have spent a great deal of money and time arguing that it hadn't. But if they'd had a written agreement by someone who understands, okay, one of the first things you want to put in is if you don't make your capital contribution, you don't have an interest until we get that from you. And so your interest hasn't vested. So it's easier to get rid of you at that point. That was a pretty expensive lesson for that client to learn. Now they have like a 20, almost 30-page agreement that's proper for a company that has like 7 partners in it.
That's an interesting story, and I could totally see, not just in law firms, but in all businesses, why it's so important to have an agreement like that. I noticed some of the areas for a partner agreement talk about minority owners and majority owners. Are there benefits that differ between those for those two different groups of ownership? I guess the two different types of owners in the business.
Well, yeah, I mean, you can imagine a situation where you have, 2 or 3 partners and they own the vast majority, and you have one person who maybe only owns like 5 or 10%, and them kind of railroading that person if they're not careful, if some of the default rules weren't in place to protect minority owners. And so there's certainly rules in place that will, you cannot divest someone of their interests. Just, for, I don't want to use the word that I'm thinking, but for giggles, we'll say.
Yeah.
There are rules you have to follow. Some of the rules that, some of the provisions we put in agreements to kind of vary and ensure that not those groups don't kind of harm each other. For example, we do what we call drag along and tag along rights when it comes time to dispose of an interest in a company. So basically what that means is if I am, for tag along, if I am a minority owner and you decide to sell your interest in the law firm or in the company, and I may not necessarily want to be in business with that person or that company you sell it to. So I will include a provision that allows that minority owner to tag along and get the same rights that you're getting when you sell your interest, meaning if you buy their share, if they buy your shares, they have to buy mine at the same, share price, for example. They can't nickel and dime me, and they can't undercut me. And then on the flip side, if I'm a minority owner or majority owner and I want to sell my interest in the company, I don't want to be prevented from doing that because, there's a minority owner who's like, nope, I'm not consenting. So then we'll put it what we call drag along rights, which means I'm going to drag you along with me. And we're going to sell the interest in the company so that, the intent isn't frustrated by someone who may be holding the deal up for any number of reasons. And you can imagine what some of those could be.
Yeah, that's really cool that things like that exist both for minority owners and majority owners. I can envision, being a minority owner and maybe feeling like you have less power. And then if someone sells, at least you have some options if you put it in writing beforehand. Is there anything?
Well, yeah, and then I'm sorry.
Oh, no, go ahead. Yeah, continue.
Well, I was going to say also, in terms of decision making, if you're a minority owner, you really want to participate in the drafting of these agreements because you don't want to give the person or persons who have the majority too much power because that could come back and bite you. You don't want, there's certain things that you may say, you know what, I think we should have unanimity on those decisions. Like if we are encumbering the assets of the company for a certain, for a loan or what have you, or borrowing money, how much we may want to put a limit on that so that, it doesn't imperil the company if we're unable to make those payments or what have you. So there's certain things that as a minority owner you have to think about, and certain situations where you may want to step up and say some of these decisions should be unanimous. I trust my majority owners up until a point, but some things should require unanimity.
Have you ever had a case where majority owners made some type of agreement without the minority owner knowing?
I mean, there are all manner of bad actors. I mean, the case law, wouldn't be what it is if that didn't happen. So unfortunately, yeah, there are people who, even with an agreement in place, will do bad things, will, commit certain actions without the consent or knowledge of their business partners. Yeah, we've had that. And that tends to lead to litigation depending on what's at stake and what that decision was. Changing, copier companies, that's one thing, but, taking assets of the company and lending them to a third party, that's something else, so.
And what absolutely has to be in a partnership agreement? Is there something that you always recommend to clients that they do that's sort of across the board? You always see certain things that have to be in there.
Yeah, I mean, there are any number of provisions that we would certainly insist on, but where I would probably start is, we know that at some point there will be some triggering event where an interest in a company will need to be sold, either, through death, disability, divorce, or retirement. And so in those instances, we want to plan ahead and deal with what we call the buy-sell portion of that shareholder agreement, or have just a buy-sell agreement. And so that is probably just the meat of your agreement if you have a law firm or any business really with your partners, is what happens if someone needs to sell their interest in the company, or that interest needs to be disposed of. How do we handle that? How do we value the interest? How do we, what triggers the sale? Who has to purchase the interest? And then how does that whole mechanism work? What's the timing of it? Just things like that. Because as you can imagine, it can be a very long and drawn out process in terms of, especially in a situation where someone has passed away, there can be some urgency in terms of getting that interest from the estate back into the company or back into the hands of the other partners.
If there is maybe a couple of attorneys thinking of starting a law firm together, maybe they've both been in private practice for a little bit and they're thinking about joining forces, what are some of the first steps they should go through if they're thinking about doing that?
I would tell them to sit down and have a very meaningful, honest conversation about what their expectations are, why they want to join forces, how they work. If you've worked with someone, you get a pretty good idea of that person's personality. It's really important that you pick a business partner in as careful a way, maybe even more careful than you pick your spouse. The wrong choice can be very expensive and emotionally and psychologically draining. I caution my clients on looking for certain kind of signs in terms of the person you probably shouldn't go into business with. There's certain personality types you should avoid at all costs. The bully and the narcissist are at the top of my list. And do not ever think, the same thing in a personal relationship, that you're going to change a grown person. They are who they are, and you should not look to enter a relationship with in your mind that I'm going to change you. Like, you're trying to run a business here. You don't have time to do that and, be the therapist for your business partner and change them. Have a meeting of the minds at the very beginning and talk about your expectations and be realistic. The partner who works with me, when he came into my firm, it was understood that he worked at a larger firm. He was tired of that grind, And he really wanted to be able to spend more time with his family. He truly wanted what they call a lifestyle firm. You hear that thrown around all the time. Well, we're a lifestyle firm. Well, technically every firm is a lifestyle firm. It's just a matter of what kind of lifestyle it is. And he wanted to join a firm where he could, here's an idea, spend time with his children and pick them up from school and take them to school and still be a practitioner. And that was fine with me. I understood his work ethic. I understood how he approached handling clients, why it was important for him to be an attorney. And those were things that we were in agreement on. We have our way of dealing with clients and our reason for even being attorneys are very similar. We're not very bottom line people. And what I mean by that is it's not, the most important thing for us is not how much money we're going to make from the client. It really is, did we make an impact? Were we able to assist that client on the issue that they brought to us? Are we able to protect them in their business, that sort of thing? So those are the types of conversations I think you should have. They're not just your standard kind of technical legal conversations, but they really have to get into the personality of the people who are coming together, and can they work together and collaborate? And then what happens when you disagree? My partner and I have had disagreements, and we've had to work through that. And sometimes that means eating some crow when you realize you were wrong and admitting it because you're an adult, and apologizing and not saying I told you so when you're right.
There you have it. Great business and life advice from Toni Long. Ladies and gentlemen, you've been listening to Toni Long, the managing partner and founder of the Long Law Group. Toni, where can people go to learn more about your firm?
They can go to our website. We are at www.tyllaw.com. We're on Avvo. We're on Super Lawyers. So they can just pop the name into Google and generally find us.
There you go. Thanks a whole lot for being on the show, Toni. I really appreciate it.
Yeah, anytime. Thank you for the great questions. This was a lot of fun.
Thanks for listening to the Esq.Marketing podcast. We'll see you again next time, and be sure to click subscribe to get future episodes.